When I'm questioning a doctor at his deposition, if I get the doctor to admit that he did something wrong, do I gloat about it? Do I jump up and down? Do I do the touchdown dance in the middle of the deposition? You want to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, I don't do any of that. You want to know why not? Because it's not appropriate. There's no need for me to gloat about something that I just obtained from the doctor that will significantly help my client's case during the course of questioning the opposing doctor, the doctor whom you have sued, in a medical malpractice case. Let me explain what I mean. During the course of the lawsuit where you have sued your doctor claiming that he was careless, causing you significant harm and injury, I will go ahead and have an opportunity to question the doctor in a process that we call a deposition. Lawyers also call it an examination before trial. It's really a question and answer session that takes place in his attorney's office, pre-COVID times. Now, during COVID times, it takes place on a Zoom video call. His attorney is there, I am there. The court stenographer is on the call as well to record all of the questions that I have asked and all of the answers that the doctor gave. The answers that the doctor gives represents his sworn testimony, and it carries the same exact weight as if he is testifying in front of a court, in front of a judge, and in front of a jury. So now, when I go ahead and question this doctor in a deposition, I have a certain agenda. I have certain topics that I need to ask the doctor about. I want the doctor to explain to me some of the medicine that's involved in this particular case. I want to see if the doctor has a full understanding from a medical standpoint of the anatomy and exactly what was done and why. I want the doctor to explain to me what the standard of care was for this particular scenario. And why is that important? It's important because in New York, the law considers this doctor to technically be an expert. Even though we question his credentials, even though we question his ability to fully carry out his understanding of the medicine, the law still looks at him as an expert, which means I am entitled to probe his knowledge of the medicine and the anatomy and to learn exactly what he believes the standard of care was for your particular situation. Another thing that I have to ask the doctor about are what we call opinion questions and hypothetical questions. We are basically working off the same set of facts. We know the facts because my client, the injured patient, has testified about them. The doctor knows the set of facts because their attorney was there questioning my client, and now the doctor may have a slightly different version of the facts as he believes them to be. So we may have different versions of similar facts, and now we have to explore them. What's interesting is that during the course of the deposition, I have an opportunity to go ahead and ask the doctor hypothetical questions. So I'm asking really the doctor to assume that our version of the facts are true. Doctor, I want you to assume that Mrs. Jones came to you with a complaint of a lump in her breast on January 1st when she first came to you. Would you agree in that instance that good medical care required you to do A, B, and C? Well, I disagree. She didn't come to me with a complaint. I said, Doctor, I understand you dispute that. However, for the purposes of my question, I'm asking you to assume that she did. In that instance, would you agree that good medical practice required that you do A, B, and C? Well, if you put it that way, yes, I would agree that good practice requires that I do A, B, and C. I will go through an entire set of hypothetical questions and get the doctor's opinion on what should be done if our version of the facts are true. And why do I want to do that? I'll tell you why. Because ultimately, if the case goes to trial and the jury believes that we are slightly more likely right than wrong than what we are claiming is true, now the doctor has admitted in his own words that if our facts, our version of the facts are true, guess what? Now the doctor has said good medical practice requires that he do A, B, and C. And in this particular instance, I am able to show, based upon the doctor's records and based upon his memory of what occurred, that he did not do A, B, and C. Instead, he did X, Y, and Z. And in that instance, doctor, would you agree that failing to do A, B, and C in light of this patient's complaint, that would be a departure from the standard of care? He and his attorney will fight me on the wording of that question. Ultimately, the doctor will have to answer the question, and if he is honest, he's going to turn around and say, yes, failing to do A, B, and C in light of this particular complaint, yes, that would be a departure from the standard of care. Now, if the doctor has admitted that, based upon the hypothetical facts I present to him. What have I done? I've now scored a minor victory in getting us to where we need to be to show that the doctor actually was responsible. Remember, during these depositions, the doctor simply doesn't throw his hands up and say, you know what, you're right. I did everything wrong. I will accept responsibility. Just tell me where to write the check out to. No, that's not how it works. The doctor does not roll over. His attorney does not roll over and say, you're absolutely right. We should not be defending this case. Just tell us where to mail the check to. That's not how it works. I have to get the doctor to admit, based upon hypothetical questions and various facts that I present to him, that if he failed to do certain things, that would be a departure from the standard of care. Once I do that, guess what? I don't have to jump up and down. I don't have to do the touchdown dance. I don't have to take a football and spike it. I don't have to do any of that. Why? Because I know what I just did. I know that I just got the doctor to admit something significant. The defense lawyer also recognizes that. And you know what? I don't do anything to make an acknowledgement that the doctor just gave up a significant part of the case. Instead, you know what I do? I just move right along and I ask my next question. I move on to the next topic. Why do I do that? I'll tell you why. Because there is no purpose in gloating. There's no purpose in doing a touchdown dance. There's no purpose in throwing my hands up and screaming and yelling for joy. Why? Because it's only a minor victory. I have to have many of these minor victories to ultimately get to the point where I can go ahead and say, yes, we are much more likely to win this case than the defense is to win. And all because the doctor has admitted various things. It's not that easy to go ahead and have the doctor actually admit something. They're not going to. So it has to be phrased very carefully, and there's no trick questions here. What I'm trying to do is to get the doctor to acknowledge that if certain things were done or were not done, that would be a departure from the standard of care. And then I have to ask, doctor, if that in fact occurred, would you agree that that caused and contributed to my client's injuries? And now he's going to go ahead and answer and explain why he believes it did or did not. So why do I share this quick information with you? I share it with you because it's important for you to understand as you are considering whether or not to go ahead and bring a lawsuit against a doctor that you believe was careless or hospital staff that was careless, and now you're trying to decide whether to go forward with a lawsuit. Well, I realize you're likely watching this video because you have questions or concerns about your possible matter. If you have not yet started a lawsuit and your matter did happen in New York and you still have questions, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.